In this video, I'm going to explain at-will employment. If you have a job in the United States, you're probably an at-will employee. So stick around to the end of this video to understand what that means for you. Now, nothing in this video is legal advice. To get legal advice, you should talk to a lawyer about your specific situation. If you live in Washington State and you think you were terminated for an illegal reason, feel free to reach out to my firm. The link to my website is in the description below. When a company hires you, you enter into a legal relationship with that company. And with any legal relationship, you have certain rights and duties depending on the relationship. So the type of employment relationship you enter will determine what your rights and duties are. And it will also determine what the rights and duties of your employer are. And with a few exceptions that I'll get into later in this video, at-will employment is the default relationship in the United States. So if you have a job in the US, you're probably an at-will employee. So what is an at-will employment relationship? Well, an at-will employment relationship is a purely voluntary relationship. And it's voluntary on both sides, for the employer and the employee. Once you enter an at-will employment relationship, either party has the ability to call it off for any reason, at will. That's why it's called an at-will employment relationship. If you decide you don't like your job, or you don't like your boss, or you just want to do other things with your time, you're free to quit your job and terminate the employment relationship. But the same is true for your employer. Your employer has the right to terminate the employment relationship at any time for any reason too. And when an employer terminates an employment relationship, they do that by firing you. So if your employer decides that it doesn't like you, or it doesn't think you fit in with the team, or for anything really, they can fire you and terminate the employment relationship. And they don't even need to have a reason. They can fire you because they felt like it. But there is one giant exception to the at-will employment rule, and that's illegal terminations. So let's go over that. Under an at-will employment relationship, employers can terminate their employees for any reason under the sun. But no matter what employment relationship they're in, employers can never terminate an employee for an illegal reason. And I've made numerous videos about these illegal reasons, but I'll briefly touch on them here too. The illegal reasons for terminating an employee are as follows. First, discrimination. Second, retaliation. Third, violations of public policy. And fourth, violations of contract. Discrimination occurs when an employer fires a worker because of that worker's protected characteristics, like the worker's age, race, gender, or disability, just to name a few. Retaliation occurs when an employer fires a worker because the worker made a complaint about discrimination or harassment. Violations of public policy occur when a worker does some activity linked to public policy, like reporting safety issues or exercising a legal right like taking medical leave or blowing the whistle on some illegal activity, and the employer fires the worker for doing it. And breach of contract occurs when an employer fires a worker for a reason that breaches a contract that the parties had agreed to. So, we just talked about illegal reasons for termination. But under at-will employment, there are also a bunch of unfair terminations that seem like they should be illegal, but they're not. So let's go over those now. First, incorrect or faulty investigations. Remember, under at-will employment, the employer is free to fire a worker for any reason. So as long as they're not covering up some illegal reason, the employer can fire the worker even though it conducted a really crummy investigation, or no investigation at all. If the employer receives some baseless allegation and it fires you for it, that's totally legal. Next is retaliation for complaining about anything that isn't protected. As we've already discussed, illegal retaliation occurs when an employer fires a worker after the worker participated in some protected activity, like reporting discrimination. But a worker might report to HR that their manager is being a real jerk or putting unrealistic expectations on them. In those situations, even though the worker's report may be totally valid, it's not considered protected activity, and the employer can retaliate against that worker without any consequences under the law. Next is bullying. Now, I'm sure we can all agree that bullying isn't okay, but it's also not necessarily illegal. If the bully is targeting you because of your protected characteristics, that might constitute a hostile work environment, which is illegal. So see my video on harassment to learn more about that. But if the bully is just targeting you because they don't like you, even though that's unfair and not okay, it's also not illegal. Finally, no cause firing. I talk to workers all the time who were fired without cause. And unfortunately, under the at-will employment doctrine, the employer does not have to have cause to fire a worker. Remember, the employer doesn't have to have any reason to fire a worker. So, I mentioned earlier in this video that at-will employment is not the only type of employment relationship. So now I'll briefly go over some other types of employment relationships that may give more protections than at-will employment. So first are contractual relationships. These types of employment relationships start and end under contract. Maybe the employer gives a worker a contract to complete a specific job or to work for a specific period of time. Under these employment relationships, the parties have to abide by the contract. And the contract usually offers more protections than at-will employment. But it's really dependent on what the contract says. Second is government employment. Some, but not all, government employees have a property right in their job. And before the government can take away anyone's property, it has to afford that person due process, which means that the government employer must give you advance notice and a formal hearing before it can fire you. Finally, union employment. Union employees work under what is called a collective bargaining agreement. And generally, collective bargaining agreements offer way more protections than baseline at-will employment. For instance, collective bargaining agreements oftentimes include a for-cause provision. And for-cause provisions require the employer to have cause before firing a worker. So there you go. Now you know what at-will employment means and why it's so important. Under the at-will employment doctrine, employers are free to fire workers for any reason under the sun, even unfair reasons, made-up reasons, or no reasons at all, as long as it's not an illegal reason. And most workers are at-will employees, because at-will employment is the default employment relationship in most states. If you like this video, make sure to hit that like button and share this video with other workers. The more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.